Anthony Johnston, assistant professor here at the law school. And it's my pleasure to introduce the ACS has brought Professor Marshall here from the University of North Carolina. Professor Marshall is a friend of mine. Before this, I'm always a fan of people who were state solicitors before entering into the academy. And Professor Marshall served as Solicitor General of the state of Ohio. In addition, he served as Deputy White House Counsel in the Clinton administration. He teaches in the areas of civil procedure, constitutional law, election law, law and religion, First Amendment issues generally, and so I think today's talk is going to give him an opportunity to expand on those and other issues about the Framers' Constitution, the real original understanding. Without further ado, Bill Marshall.
Out today. In North Carolina, if they hear that there is a snowflake in the next county, they can't be stored. This is a real pleasure to be here. I'm actually from New Hampshire originally, so this is like old home. It's old home for me in another way too. One of my first jobs was the summer after my first year of law school. I did legal services out in Anaconda, Montana. I did circuit for Phillipsburg, Dillon, Virginia City, and Deer Lodge. So I love this state. This is one of my favorite places in the world, and it's really an honor to be here. Let me thank Anthony for his kind introduction. Anthony's terrific. You don't know how lucky you are to have him here and join the faculty. Thank Noah for all the work you've done putting this together, and let me thank Papa John's for providing the pizza, because I've been at law schools enough to know that you cannot have lunch talks without pizza. Nobody shows up. Hopefully they will show up, and when they do, please get up and get it, and don't worry about any disturbance. I've talked over a lot worse than people getting up and having pizza, including booze and everything else. For the last 30 years, there's been a mythology, or maybe even 40 years now, a mythology propounded in popular culture. Under that mythology, conservatives apply real law. And what liberals do is they do anything they can to reach the result that they want to reach. And this is popularly ingrained, the idea that activist judges just do liberal results. And what conservative judges do is actually follow the law. Chief Justice Roberts, they just call balls and strikes. That's all they do. They aren't interested in any political results. And this is the original understanding of what law should be. A big part of that, I agree with the original understanding of what law should be, is that people shouldn't try to do anything to effectuate political results. If you have a legal philosophy that justifies all of your political positions, you don't have a legal philosophy. You have a political philosophy that you are just attempting to stick in a current mold to get to the results you want. But the rest of the analysis is missing a few things, because it ignores really what conservative jurisprudence is all about and what I think actual jurisprudence is about. And what I want to do is talk a little bit about that. The rise of the conservative critique really took place after the Warren Court, with the major decisions like Miranda versus Arizona and school prayer, and then later on under Chief Justice Berger, Republican, abortion. And liberals were criticized as being activists, and conservatives again followed the law. At that time, the critique was that the court should defer to the political actors. That what activism was overturning the decisions of the political branches. That's what was wrong. Slowly but surely, the conservatives began to take over, in a much definite way, the federal courts. And you saw a conservative majority. By the way, 11 of the last, up until Sotomayor and Kagan, 11 of the last 13 Supreme Court justices were Republicans. There has not been a majority of Democratic appointees on the Supreme Court for 40-something years, and yet the Republicans still run against the Supreme Court. Go figure. But then they moved, after they consolidated the authority on the federal courts, they changed their definition of what activism was and what conservative jurisprudence was. No longer was it deference to the elected branches. Now it was something they called originalism. Why? Because they started striking down laws in droves. No longer did they buy what they were doing. They needed a new theory, so they came up with this theory of originalism. And it was Mies, Ed Mies, Robert Bork, and Nino Scalia developed in a series of articles this notion of originalism. And now first they said it was original intent, what the framers wanted. That didn't really work out so well because you really couldn't come up with a First Amendment as to what James Madison would have thought about movies, or more recently what he might have thought about the internet. So then they started taking it a little bit further and said what people might have thought about these concepts, and we might move it a little bit forward to recognize changes in technology. But the point I want to leave with you is that this notion of originalism, which you hear about so much, isn't all that original. It's basically been around for 30 years. Or 40 years. There are some Supreme Court decisions from the 19th century that seem to look in a very rigid way at what the terms mean, but the leading decisions from the 19th century, the leading decision from the 19th century, was McCulloch versus Maryland, in which Chief Justice John Marshall, no relation, so I'm giving him a plug, where Chief Justice John Marshall said, we always must remember it is a constitution we are expounding. Not a statutory notion, but a constitution, something that we understand has some sort of way that we need to look at it over time in a way that makes sense. Think about the wording used in the Constitution: due process, equal protection, which came from the 14th Amendment, freedom of speech, executive power. What do those terms mean? It's not like if you got together James Madison and Thomas Jefferson and Gouverneur Morris and Patrick Henry in the room, they could define those terms or could define it even then. Many of these terms are the result of political compromise. And Patrick Henry and James Madison had about as much in common as John Boehner and Nancy Pelosi in terms of their political ideology and what they believed in. These were terms that were compromised, and they were also deliberately chosen because they were something that could be interpreted over time. There was no precise definition. There was no self-definition to these terms, and it allowed for these terms to be interpreted in a way that made sense in the context that they would eventually be interpreted. And let's also remember that the founders were common law lawyers. They understood the way law moved. I don't want to use the term evolve, because the important thing is the constitutional principles stay the same. The commitment to liberty, the commitment to equality stay the same, but their applications might change over time. What the originalist model fails to do is to recognize that the framers were visionaries. The framers weren't interested in just solving the problems before them. They were interested in setting up a structure that would last for centuries. And we are very lucky that it has, precisely because it has been able to accommodate the changes in society that have taken place since the original founding, and that is exactly what the framers want. The originalists forget that, and I think what the originalists do, and I'm going to use an originalist term here, a framers term, they diss the framers. Because they suggest that the framers could not see beyond their own world. They suggest that the framers were not setting forth something that would last throughout time. And I think in that sense they're giving a short shrift to the framers that John Marshall, who by the way was a contemporary of them, understood immediately. It is a constitution that we are expounding. Think a bit about what originalism might mean. I have not heard the leading originalists say, let's abolish the Air Force. But if you're an originalist, you should. There is absolutely no constitutional authority to have the Air Force, among other things. Think about some other principles of, we think about one person, one vote as essential to who we are as a democracy. That's not originalist. The originalists, the framers, did not live in an era where there was one person, one vote. Very few people had the right to vote at all. and the legislators and the legislatures that existed were very skewed. You can't justify that under originalist theory. You can't justify Brown versus Board of Education under originalist theory. When the 14th Amendment was adopted, there was no indication that the framers of the 14th Amendment would have believed in integrated schools. Gideon versus Wainwright, we make movies in honor of Gideon versus Wainwright. Right to counsel, not a chance that that could be accepted under an originalist view. So you know, they're ignoring the way that we've understood what our Constitution is and what our Constitution means. Now I'm saying that they're going to overturn Brown, they're going to overturn Reynolds, which is the one person, one vote Gideon. I don't know, because that leads to the other problem with respect to originalism. And that problem is that the conservatives apply originalism, honestly, straightforwardly, without compromise, because they believe in integrity. They do this every single possible time, except when they don't. And when they don't, it constitutes a fair amount of some of the major decisions of constitutional law in our current period. You cannot, under any originalist theory imaginable, suggest that federal affirmative action is unconstitutional. You can dispute whether affirmative action is good. But you can't say it's originalist to say that federal affirmative action is unconstitutional. Why? First of all, the feds provided all kinds of special programs for the recently freed slaves after the Civil War when the 14th Amendment was adopted. And second of all, and even more importantly, is probably perfect timing. Okay. But even more importantly, the 14th Amendment doesn't even apply to the federal government. It applies only to the states. You can't come up with a textual argument. You can't come up with a historical argument that suggests that federal affirmative action is unconstitutional, and yet that is central to conservative jurisprudence. When Justice Scalia in the Lucas case started trying to make arguments that there were all kinds of property exceptions to attempts to engage in environmental regulation by communities and preserve beach space, he relied on constitutional culture. Hello? When he talked about in the Smith case, when he tried to distinguish Wisconsin versus Yoder, which said that the Amish had an exemption to having to be compelled to engage in compulsory education, he said hybrid rights is what protected them. Hybrid rights? Madison and the Beefalo? I mean, what's he talking about? This stuff is made up. And it's made up to create the results that they want to reach. Citizens United, the argument that the framers, or the people living at the time of the framers, would have believed in unencumbered corporate expenditures is nonsense. Corporations were completely tightly limited during this period. They had very, very narrow leashes. And their charters were extraordinarily confined as to what they could do. You can't come up with an originalist theory that supports corporate expenditure. You might come up with an originalist theory about speech, suggesting that that might come up and protect campaign finance. But to suggest it protects corporate expenditures is something different. There is pizza here. I'm serious. Come up and start cooking it now, or it's going to get cold. And then you're going to be mad at me afterwards. So please. Somebody do it. Good. Okay. I was a student once myself. I know what you have to do in order to survive, and that includes pizza.
Did you drop off napkins?
While everyone's grabbing pizza, I'm going to put this right here. This is a sign-up sheet. If anyone is interested in joining ACS or receiving emails or finding out about other events like this, when you're grabbing pizza or on your way out, come by and sign up. I have pens and I will.
Okay, break time's over. If you take a look at originalism as applied by the conservatives, it's not really, one of the arguments that is made in defense of originalism is that what we don't want are judges making political judgments, and if we require judges only to apply an originalist understanding, then we'll not have the discretion to be able to achieve the results that they want. But if you take a look at the way originalism has been applied, it doesn't escape that critique. It reinforces that critique. Some of the most central parts of the conservative legal agenda, the protection of property, the attack on campaign finance, and the attack on affirmative action, all cannot be justified under originalist theory, and they know it. So what's left? I mean, what is the other side? What does it mean to say we must all remember that it is a constitution that we are espousing? What does that mean? I think it means two separate parts. One is that, first of all, we understand we live in a democracy. And when we live in a democracy, the vote of the people counts. So one of the things that a court must do, and the conservatives used to believe this once upon a time, was to engage in judicial restraint, which meant deferring to the political branches in certain circumstances. I think that's right. I think that critique is right. You defer to the political you defer to political decision making because those were the democratically elected officials. And you do that in most circumstances. But there are kinds of circumstances where you don't do that. And this was recognized by Chief Justice Stone in the 1930s in the famous Caroline Products case, the most famous footnote in the history of constitutional law, where Stone said, you defer in most circumstances, but you don't defer when the law itself might be subject to the notion that it wasn't, that its result didn't conform to really what you want a political process to be. So if the law has affected the validity of the political process itself, it limited people's right to vote, or it eliminated people's right to speak in terms of campaigns or other things, you could have greater judicial scrutiny to examine that kind of law than you would on a basic law regulating economic conditions. That was one exception, number one. The other type was, what about if a law singled out discrete and insular minorities for adverse treatment? In that circumstances as well, then again, judicial intervention was appropriate. So again, the basic rule, you defer in most circumstances, except when you're dealing with these categories of the integrity of the political process and discrete and insular minorities, and then a little bit of what you might want to call fundamental rights. Now, is this an easy analysis to apply? Does it lead to scientific results? All of you in first year con law, you want to know what's the answer. Is there an individual right to bear arms or not under health? What's the right answer? I got a problem with that. There isn't really a right answer in the sense of a scientific result. What a court does and what a court should do, and what it's done for the 200 years of the Republic, over 200 years now, of the Republic, is it takes a look at history. It takes a look at text. Yes, originalists do that as well. But it also takes a look at how those matters fit within the society and come up with a result, taking a look at the ongoing and principles, the long-term principles set out in the Constitution. I think Heller's a close case. I think it could come out either way. It was a 5-4 decision. But that's what you get with constitutional interpretation. You don't get scientific results, but you don't pretend that there is an originalist answer out there that somehow, automatically, reaffirms all your pre-existing political convictions. That's not honest. And there's honesty on the other side, too, by the way. I think one of the most dishonest decisions that I've seen recently is the dissent in the McDonald case, which said that the Second Amendment decision in Heller shouldn't be applied to the states. I think that Heller itself, whether it's an individual's right to bear arms, I think is debatable. But once you came up with that, I think what the liberals did, saying you shouldn't apply to the states, is nonsense. If you say that there's a constitutional right in the way that Heller did, you might want to overturn Heller, that's one thing. But don't keep Heller alive and then say it shouldn't apply to the states. That just seems to me exactly what I'm criticizing here. A result-oriented decision-making process that neither side should be justified in doing. So what do we need to do? You know, what do we need to do in terms of changing this rhetoric out there? Because I think that's really the issue. I will give the conservatives all the credit in the world. They have won the larger media debate on this issue. You ask most people, liberals are out there, they're just trying to get results that they want. Conservatives, they're applying the law. Well, I think what we have to do is point out that that's not exactly right. They gave us a great piece of water for that, Citizens United. When they went there, they really exposed in a very blatant and very public way that they weren't engaging in any sort of originalism. But I think what we also really need to do is address it at the basic notion of what the framers really were. And I want to end, and I'll take your question. I want to end where I started, with Chief Justice John Marshall. And the first major constitutional interpretation decision that the United States Supreme Court ever issued, McCulloch versus Maryland. Marbury established judicial review, but in terms of setting up what constitutional interpretation should be, McCulloch is the first and primary case. And he said there's a constitution that we are expounding. That, in fact, intended, I want to give the exact language here, we must never forget as a constitution we are expounding, intended to endure for ages to come and consequently to be adapted to the various crises of human affairs. That was written in 1819. So if you want to go back to originalism, if you want to talk about what originalism really is and what originalist interpretation really is, then pull out my great-great-grandfather John's quote as really the framework of where it begins. So those are my set comments. I love taking questions, so fire away. I hope there are members of the Federalist Society here, because I love appearing. I talk at Federalist Society conventions all the time, and I love talking to them. And it's really, this dialogue is really important on both sides. We are so polarized, we don't even know how to talk to each other. My dad was a conservative Republican. My mom was a liberal Democrat. I've got shades of my mom was smart, but I got shades of both of that in my background. I grew up in New Hampshire, live free or die, a state that makes Montana look leftist. So really, let's have a real dialogue. Yeah.
Could you talk a little more about the sort of exercise of judgment that's required to get this vision of the framers applied in the context of difficult cases?
Sure. Let me give an example. One person, one vote. Reynolds versus Sims. Baker versus Carr said that, supposed to review it. Reynolds said, one person, one vote, which is something that the framers never would have gotten to. At the time of the original drafting of the Constitution, voting was limited by gender, usually limited by property rights, limited by other kinds of, limited certainly by race as to who could vote. By the time the 1960s come around, you've got universal suffrage. You've got minorities can now vote, women can now vote. There are no property limitations left on who has the right to vote. So when you take a look at the Equal Protection Clause and voting together, it suddenly makes sense that if everybody's got the right to vote and we have a principle of equality in the Equal Protection Clause, then it makes sense, one person, one vote. But let me give you another example. One of the most important First Amendment decisions of all time, and one of the most courageous First Amendment decisions of all time, West Virginia Board of Education versus Barnett. I don't know how many of you in law school have looked at this. This is a case decided in the middle of World War II, which held that the Jehovah's Witnesses had a First Amendment right not to be, under the Free Speech Clause, not to be compelled to salute the flag. 3 years earlier, the very same Supreme Court had rejected the notion that the Jehovah's Witnesses could refuse to salute the flag on religious grounds. There had been a change in personnel. The case comes up to the U.S. Supreme Court in the middle of World War II. And the United States Supreme Court, in one of the most beautifully worded decisions of all time, written by Justice Robert Jackson, holds that Jehovah's Witnesses cannot be compelled to salute the flag. There is not an originalist argument that I am aware of that would suggest that the framers of the First Amendment would have found a First Amendment right not to speak. There's no text to that basis. There is no, there were compelled oaths during that period. There were certainly compelled oaths at the time of the 14th Amendment being enacted. If you were a Southerner, you had to profess loyalty to the United States. There were compelled oaths there. And nobody thought that it raised the First Amendment challenge. What happened in the middle of World War II to suggest that a fundamental First Amendment right was at stake when people were being compelled to salute the flag? Quick answer: Nazi Germany. And we could look across the globe and understand that if we had a commitment to freedom of speech, that it had a different implication when you forced people to salute the flag than people might have thought about at the time the First Amendment was enacted. That, I think, is the right method of constitutional interpretation. An originalist who was being honest would have to have come the other way on Barnett. And yet I think Barnett is one of the most important cases the United States Supreme Court has ever decided. And by the way, it sent a nice message across the continent, across the ocean, as to what the United States really stood for. Yeah.
I agree about conservatives winning the public discourse, and that conservatives apply original intent. Liberals are going for the result. Within jurisprudence, what I see in the Supreme Court, and in the circus to the extent they're trying to do originalism, is that it's drawing what you would think would be liberal, democratic justices or judges to operate within the original intent analytical framework. Maybe you don't see that, but it seems that over the last 10 years in particular, that Scalia and Thomas are getting judges to operate within original intent jurisprudence. So what's the draw that's bringing seemingly liberal judges into that framework?
I think your point is Heller was an interesting case jurisprudentially because both sides argued basically an originalist model. And in that sense, there was a triumph. I think part of the problem was labeling. Because part of what originalism says is important to constitutional interpretation. I agree with it. You want to look at text. You want to look at history. But you want to do that to try to figure out the broader principle involved and not use it to sort of confine the answer into an 18th century framework. That's the difference. I mean, I think it's important. And anybody in order to make a good argument, invoking history and invoking text is really important. But you don't frame it, you don't freeze it within the notion, and the healthcare debate is a good example. The notion of commerce has changed since the time of the enacting of the Commerce Clause. We now understand that if somebody sneezes in this class today, and I take that back to North Carolina tomorrow, there's an effect. There is a different kind of commerce effect that takes place because of the way society has changed. That gives a meaning to the Commerce Clause in the 21st century that it might not have had in the 18th. So I agree with you that this debate has had judges on both sides do a little bit more historical research than they had otherwise, but that's only a starting point. It's not an ending point. And by the way, the worst historians out there are lawyers. Because what do lawyers look for? They scour the historical record, and the one sentence they can come up with that supports their legal argument is the one they take. It's not real history. Yes.
So that speaks to the question I had. Those who advocate this originalist theory concept, where do they look? I mean, is it the minds of the framers, the minds of the states that are being represented, the minds of the people? I mean, how far out do they cast this?
They look at whatever gets them to where they want to go.
So that's.
I mean, they really do. It's not. I mean, that there are times. There are some I don't want to criticize all the originalist decisions. I mean, Justice Scalia has took a very courageous vote against restriction on flag burning, for example. But usually it takes them always to the place they want to go. It's almost like James the Mint was a framer in terms of how they get to the results that they want to get. I think what you do if you're going to take a look at the historical record, you take a broad look at the historical record, and you recognize things on the other side too. And you take a look at text, but you're taking a look, I really think, at the broader principles that the framers were dealing with. Why did they have freedom of speech? And then if we talk about why they had freedom of speech and what was motivating them and what that principle was standing for, it becomes a little bit easier to apply it. And that's what I think you should do. But I mean, if you take a look at the historical analyses by the court, I don't know, where does Justice Scalia come up with constitutional culture? And first of all, what does that have to do with originalism anyway? Yes.
I have a question for you. In regards to the 14th Amendment, there's a clause in there about privileges and immunities, but the court, which obviously seems to have a 5-4 stint toward the conservative side, doesn't even seem to be able to utilize privileges and immunities or even want to touch privileges and immunities, and everything gets evaluated under due process since 1920 something. But yet, you mentioned the Carolina products, where obviously the court's recognized that there's certain places where the court needs to step in and define privileges and immunities. But yet, it would seem under an originalist argument that the court would be the place to actually go out and decide what these certain rights are for the people, as opposed to a political process, which can obviously cause bad results.
Yeah, I mean, yeah, and Justice Thomas made some nods for us. I mean, the question here that's being raised is, do the Bill of Rights, which, if you read them, apply only to the federal government, apply to the states? And after the 14th Amendment was enacted, there were two different ways it was argued they apply to the state. One was through the Due Process Clause of the 14th Amendment, and one was through the Privileges or Immunities Clause, also of the 14th Amendment. The court in the 19th century rejected the Privileges or Immunities Clause, and we've been living with that ever since. The question is whether that's right or not as a matter of historical accuracy, and I think they're pretty good historical arguments that the rights should have been applied to the states through the Privileges or Immunities Clause. Of course, not going there, I'm not sure how much difference it would make in terms of what the rights actually are. But, you know, I think it's a valid point. Yes?
For those who apply the originalist understanding of jurisprudence is, how far back do you go? Do you go to the amendments when they were enacted to determine the original understanding, i.e. the 14th Amendment, 1868 or ish? Is that when you would, where you would draw the line, or would an Antonin Scalia, for example, go back to the originalist understandings during the framing of the Constitution itself?
Good question. There's a debate on this. One is you take a look at what the framers were, what the original meaning was at the time of the framers, and that might even take you back to a history beyond that, because they might be thinking how the framers themselves were historically informed. The second argument is that you also need to take a look at the framers of the 14th Amendment and what they thought. Because if we agree that the framers of the 14th Amendment wanted to apply the original Bill of Rights to the states, then you might take a look at how they believed or what they thought of the Bill of Rights. And there's a law professor at Yale, Akhil Amar, who's written a great deal on basically the second founding period, and saying that you can't just look at the time of the original framers in deciding what the Constitution means. You also have to take a look at the time of the enactment of the 14th Amendment to try to get some understanding even of what those original provisions meant that were enacted in the 1780s.
I'm interested in hearing your thoughts on the current term, and we'll just go ahead.
On the current term?
And yes, yeah. And the future, I guess.
I think healthcare is going to be really interesting. Not just because of what it is, but because of the way it's decided. The interesting thing about the case is most people wouldn't have thought this was all that controversial up until about years ago. And what we've really seen, and this is one of the downsides, by the way, of constitutional interpretation and not having a scientific residue that we can say has the right result. People's views on the constitutions have changed because of popular movements in the last 5 years. If you take a look at precedent, at the Wickard versus Filburn case and the Raich case, Gonzalez versus Raich, this is an easy case. Healthcare is 1/6 of the economy. The decision not to buy health insurance is a decision to self-insure. The decision to self-insure affects the health insurance rates that we all have to pay. And when people show up and they don't have insurance and a hospital has to give them treatment, that also affects the health care insurance costs that we have to pay our health care bills. So it's a relatively easy case under the old understanding. We'll see what happens here. It would be, I think, Justice Thomas is a definite no. I think Justice Alito is the next most likely definite no. But Justice Scalia wrote in the Raich case, which was the regulation of medical marijuana by the federal government. Somebody grew some marijuana in their backyard for themselves. And the question was, does the Commerce Clause reach that? And the same kind of arguments were raised by the federal government. You know, it affects the price of marijuana and whether people are home growing it. And it does. Not that I have that personal experience. But it affects it, and Justice Scalia joined the majority. And this, by the way, is part of the problem with originalism. Do we really think that, you're hearing this great argument by the Republicans in Congress, we've got to protect the rights of the states. Except they're trying to nationalize tort law. And they're trying to nationalize property law. These are arguments that are used only as a matter of convenience. And I understand, by the way, I grew up in New Hampshire. I understand distrust of the federal government, and there's a lot of reasons to distrust the federal government. And there are a lot of people on the left who should always remember that there are reasons to distrust the federal government. It isn't always a benign force. What confuses me is why people think that the example of totalitarianism is health care for everybody and not a president acting alone being able to pick up an American citizen, throw that person into detention without notifying that person's family or giving that person a lawyer. That strikes me as much more of an example of totalitarianism than does national health care. But the same folks who are up there now saying that their rights are at stake were strangely silent when that was taking place in the United States. And my question is why? Be consistent. Yes?
So doesn't your argument kind of just boil down to that people are biased in their decision making, and even though it's just cast in an originalist net? I mean, you raised one example with the liberal justices and their dissent, but isn't it that just that people make biased decisions?
I think people do make biased decisions. I think what a judge is supposed to do is fight those instincts. I think David Souter was a good judge.
How do you, if it's not based on that originalist formula or another formula, what type of, structure should be imposed, or should they base their decisions on just completely objective, non-emotional?
I think when you take a look at the president, you take a look at their history, and you take a look at, it's not a scientific process as I indicated, but it also means a much more willingness on both sides to come to results that they don't like. And an acknowledgement that being a judge and being a constitutional judge or justice might lead you to results that you don't like. We're seeing such an over-politicization of law right now that I can understand this hunger to give us some science, because it doesn't scientific answers. But I think that requires the appointment of justices who really will put their own beliefs aside as much as they can to try to come to a fair determination. We've had some in our history. I think John Harlan was one of those. I think David Souter was one of those. And we'll see if some other ones happen. I've been avoiding calling on Anthony because I knew he'd been asking.
No, well, I want anyone else.
Okay, Anthony, blow the argument out of the water. Go ahead.
I'm just trying, so you're talking about it. Well, of course, there will never be another Justice Souter because he was a huge mistake. So every Supreme Court justice we have now are people who have records of working for presidents of the party, except for Sotomayor. And you get people from the White House counsel's office because they're true believers, and that's gonna stick. So I'm trying to figure out how we get to this. How do we get justices like you're talking about based on a footnote in a Supreme Court case that's been around for 65 years? I'm trying to imagine the Senate confirmation hearing or the political campaign that gets us justices in the mold we're talking about.
Yeah, well, see, I give you a nice idealized vision, and what do we get? Reality. Right? Our political process is not healthy right now, and we used to have 3 political parties in the United States: the Republicans, the Northern Democrats, and the Southern Democrats. And it forced people to work across party lines. What we've got now, you combine that with campaign finance and the way that campaigns are financed. It's one thing if I try to convince you to vote for Tester over Rayburn, and I give you a nuanced argument. It's another thing if I want to raise $2,000 for you for the race, in which case I have to paint the other side as being evil. And that adds to the polarization. And finally, you get redistricting, in which the creation of safe districts means that the only people who are really safe in those districts are the ones who appeal to their party's extreme. And so you get situations like Bob Bennett being defeated in a Senate primary in Utah. Bob Bennett, incredibly conservative, or Bob Inglis, the problem is having the first name Bob. Bob Inglis in South Carolina, also very conservative, being beaten in the primary. I don't know. I don't know the answer to your question. I don't know how we create a greater bipartisanship than we have, and a greater notion that the responsibility of our elected officials is not just to their party's extreme, but to a general notion of commitment to constitutional fealty. I mean, I've worked on a lot of judicial nominations. I think it's a tragedy in what it's come to that anything you've said once upon a time will kill you, either by your own side. If you are Jeff Sutton, let me give you an example of Jeffrey Sutton. Jeffrey Sutton is a Sixth Circuit Court of Appeals judge, one of the most conservative people in the country. He's a former Solicitor General, so Anthony and I love him. But he's one of the most conservative theorists in the country, one of the primary architects on some of the federalism theories protecting the states. He just wrote an opinion upholding the health care bill. He is dead as a potential candidate for the U.S. Supreme Court by the Republican Party. It shouldn't be this way. The more you have a record, the more you get disqualified, either by your own side or by the other side. And until we sort of quell some of the political divisiveness, it's not going to get better. That said, one would hope that when somebody gets to the Supreme Court, that they begin taking their role seriously, that it's different than the role that they had when they were an advisor to the president, or when they were at the Office of Legal Counsel. Whether they will or not, I don't know. We'll see how these particular justices evolve if they do. Yeah.
Going back to the Commerce Clause, you mentioned race and regulation of marijuana, and I'm spacing out the name of a case from North Carolina last year. It was argued by a Durham lawyer about post-prison confinement if you're a sexually dangerous person. Yes. So if you look at those two cases, and the Supreme Court in that case said it's permissible for the national government to regulate both those areas. Those seem to be a consistent extension of the New Deal jurisprudence. But then how do you explain Lopez, Jones, and I'm forgetting the third case, but those 3 cases in the late 90s, early 2000s that were cutting back on Commerce Clause powers, which I think is very important relative to the healthcare case.
Yeah, Lopez is easy. The way that it was argued, there wasn't much of an argument tying guns near schools to the economy, to a national economy. That was all in a direct way. That wasn't argued that way. That wasn't a record on that. Morrison was a little bit harder because there was a record indicating that domestic abuse and domestic violence had economic effects. Those are the precedents the other way. How they reconcile with race, I don't know. How could those who flipped on those cases live with themselves? I don't know. How did Justice Scalia vote to strike down the law enforcement in Morrison and uphold the regulation of medical marijuana. I mean, I get worried that people are making their decisions on the basis of whether or not they like the underlying law more than they are on their understanding of the Commerce Clause. Yes.
Why is the judiciary and the federal government so afraid of marijuana?
That I can't answer. I don't understand. I just read, if you're interested to me, a very interesting historical book that I just read, Last Call, which is about prohibition and how the Prohibition Amendment was enacted. It's a nice little sense of why people react the way they do to these kinds of things. Take a look at it, maybe we can get some insight. Yes.
Does anybody draw parallels between the originalist discourse and forms of fundamentalist religious interpretation of Scripture?
Yes. There are some people who are taking a serious look at that, that what people are looking for is that same kind of certainty that they feel that they can find in Scripture. Now, of course, you can pretty well get any kind of argument you want out of Scripture. It's not as solid as they say it is, but yes, there is some notion that this really is a fundamentalist kind of enterprise taken up. Now, my point on that is two things. One is, it's not there. And the reason why it's not there is because the framers didn't want it to be there. I have no idea whether the author of the Bible wanted it to be there or not, but I can tell you that the framers didn't want the term due process to be etched in stone. And the second thing is that the theory is just being manipulated to whatever results they want to really get. But yeah, there's some good literature out there on people who are looking at exactly that and tying it to social movements. Yes.
I have a question just about precedent and when or what factors do you think justify it in court when they overturn precedent and when should it be upheld? Because it seems to me like it's just sort of popular consensus when precedent is changed. I mean, sometimes that seems like a good result, but I'm just wondering what justifications and factors go into making that decision.
Yeah, that is a very tough question. When do you precedent, I think, is an important tool in decision making. When do you overturn it? When do you decide Plessy versus Ferguson, which is the case upholding separate but equal? When do you decide that gets overturned? I can't give you a mathematical formula on that. I think that you take a look and see if the social conditions that justified that at the time it was decided are still there, or that supported that it was still there. I think you can take a look at see how other precedents have evolved, would suggest that maybe this precedent is no longer valid anymore. I do think that the thumb has to be on the scale of upholding precedent for the most part, and it should be exceptional rather than ordinary. But I can't give you mathematical formulas now. I do. It's a great question.
Yes.
Could you talk about Citizens United in that context? Are they, any chance that they realize they made a huge mistake? Would overturn it immediately? Or do we have to have this constitutional amendment?
You know, I hope we don't. I mean, constitutional amendment is a dangerous game. It's a really dangerous game. We have never amended the Constitution to restrict a right, except for prohibition. And we repealed that one. Citizens United seems to me its biggest error was in the way it treated corporations, not necessarily the way that it treated campaign expenditures. And there, the court, to get where it did, overturned a couple precedents. It also overturned really 100 years of history of the regulations of corporations. But I don't see any easy way around that right now. I think it's going to have to depend on which justices get nominated to the Supreme Court and which ones get confirmed to the Supreme Court. And I don't like that answer, because that suggests the law is more political than it should be. But I think that's the realistic answer as to how it will be overturned. They were firmly committed to that decision. And we have yet to see how bad that decision is in terms of its practical effect. We are in a worse system now than we were without any campaign finance at all, finance regulation at all. Well, we didn't, at least then, the candidates and the parties were the ones who were making the message, and they could be held accountable. So if I got up there, or somebody got up there and said a really nasty thing about somebody else, you could say, well, the candidate there did that, vote against that person because they lied about me. You can't do that when the ads are coming under the name of Citizens for American Progress or Moms for Apple Pie or something like that. So, you know, it's a serious problem. And these ads are vicious, and they're often wrong, and there's no accountability whatsoever for them. At least when they were being spent by the political officials themselves, there was some sort of accountability. Any more questions? We all agree then? All right, thank you all for coming out today. Thank you for being